Thank you very much. The next item of business is a debate on motion 23884 in the name of Hamza Yousaf on the Covered Human Intelligence Sources Criminal Conduct Bill Legislative Consent motion. Can I invite members who wish to speak in this debate to press the request to speak buttons now, and I call on Hamza Yousaf to speak to and move the motion.
Thank you, Presiding Officer. I've tabled this motion to update the Scottish Parliament on the Scottish Government's position on the UK Government's Covert Human Intelligence Sources Criminal Conduct Bill. The bill completed report stage in the House of Lords on the 13th of January, and the third reading is scheduled for later this month on the 21st of January. The bill aims to provide an express statutory power for certain public authorities to authorise a covert human intelligence source, otherwise known as a CHIS, to participate in criminal conduct where it is necessary and proportionate to do so. The Scottish Government lodged a LCM, Legislative Consent Memorandum, on the 4th of December 2020. In the memorandum and during the evidence session with the Justice Committee on the 15th of December, I confirmed that the Scottish Government could not recommend to the Scottish Parliament to give its consent to the bill. This was because, despite considerable debate and discussion with the UK Government, safeguards which, in my view, are essential to regulate the very significant power being granted to authorise criminal conduct were missing. Despite some limited improvements... yes, I will.
Neil Findlay.
I wonder if the Minister would consider this, that the greatest safeguard that we could have is that if the Scottish Government brought forward its own legislation in this area and allowed this issue to be debated seriously through our political system, and then we make a decision on it. That would be the best way to get safeguards.
I agree, and I'll be suggesting that's the way that we progress, but I'll get to that issue in a little bit more detail very shortly. In relation to where I was previous to the intervention, there has been some limited improvements, but unfortunately I remain unconvinced that there are sufficient safeguards and protections built into this bill. Throughout the passage of the bill through the Westminster process, I've continued dialogue with the Right Honourable James Brokenshire, and at this point, can I say, Presiding Officer, I understand that he has taken a period of curative leave, and I wish him a very speedy recovery. I have been paying close attention to the debates during the passage of that bill in the hope that a Four Nations agreement could be reached. However, I am disappointed to report that despite very candid engagement with the UK Government, they have not brought forward amendments to the bill that would satisfy my concerns. The bill remains deficient in my view, and I know that many members share that view. There has been no movement towards prior judicial approval by a Judicial Commissioner at IPCO. Prior approval has always been my preference. It is supported by the Lord Advocate from his perspective as head of the system of prosecution, as well as the Chief Constable. Having followed the debate at Westminster, my preference for prior judicial approval has actually become stronger. I know the Law Society sent a briefing round to MSPs, the Law Society of Scotland, they share that view on prior approval. Prior approval, by providing independent judicial scrutiny of the decision reached by the authorising officer for a criminal conduct authority before any activity takes place, would, in my view, go a long way to addressing legitimate concerns expressed in various quarters. During the House of Lords stages, the need to address non-permitted conduct in some way on the bill has also been raised. It's also an issue that has been raised by many a respected human rights organisation. I acknowledge and share these concerns, but I also recognise, of course, that it's not always a straightforward issue, especially if not dealt with on a Four Nations basis. Nevertheless, I'm not convinced the bill at present adequately covers that issue. I know there has been a reliance from the Conservatives on the Human Rights Act, but they will forgive me, they are also the party that has instructed a review of that very Human Rights Act, and therefore I think that position is somewhat disingenuous. This is a complex area of law. I acknowledge the forthcoming Court of Appeal judgment may require a legislative remedy, and that allows me to close on the point that Neil Findlay raised. Until that judgment is known, we obviously don't know what, if any, remedial action will be required to amend the Regulation of Investigative Powers Scotland Act, RIPSA 2000. As the Scottish Ministers cannot recommend that this Parliament consents to the bill, there may be a need for either emergency or expedited legislation to cure what will be an immediate consequence arising for the Court of Appeal judgment when it's known, and that would by necessity be no more than just a sticking plaster to ensure the security of police operations. If such a measure is required, it would only be a stopgap to allow a full assessment of the Court of Appeal judgment. That assessment will in turn inform any subsequent measures that may have to be put in place by this government or indeed by any future government post-elections. And we would do that, of course, in the fullness of time and with the fullness of parliamentary scrutiny. So, in conclusion, Presiding Officers, the UK bill stands. I am unable to recommend to the Scottish Parliament that it gives consent to the Covert Human Intelligence Sources Criminal Conduct Bill, and I move the motion in my name.
Thank you very much. 3-minute front-bench speeches, please. Liam Kerr to be followed by Rhoda Grant.
Thank you, Presiding Officer. And at the outset, let me thank the Cabinet Secretary and especially the relevant agencies for their engagement throughout this matter. In my 3 minutes, Presiding Officer, I'll argue against this motion and ask Parliament to give its legislative consent. The Cabinet Secretary has said of covert human intelligence sources, they can be vital to the gathering of sometimes life-saving intelligence that cannot be gained any other way, or to disrupting serious crime and security threats to the nation. He continued, in Scotland this activity is used to tackle organised crime in drugs and weapon running, human trafficking, child sexual abuse rings and terrorism plots. And he concluded that a source's participation in criminal activity may at times be necessary. Now, the ability to carry out this vital work presently lacks a statutory foundation. A court case has been brought against the UK relating to covert sources, and the Court of Appeal will promulgate its judgment on that soon. It is possible that the court will find that the current system of covert surveillance is unlawful. In such event, the UK would have no basis for undertaking covert surveillance into, for example, terrorism, cybercrime, people trafficking, or drugs running. Now, the UK bill anticipates this, setting a statutory framework allowing our security services and our police to continue to protect us. That bill contains provisions to ensure such practices can continue in Scotland, hence the request for legislative consent today. Now, the Independent Investigatory Powers Tribunal in 2019 said of the system which the bill enshrines that authorisations were exercised with scrupulous care so as to discharge essential functions in protecting national security, whilst giving proper regard to human rights. The UK Government has tried to accommodate requests from the Scottish Government, including, for example, an agreement from operational agencies to discuss a memorandum of understanding with COPFS. Yet the Cabinet Secretary asks Parliament not to consent today. If it does not, the UK Government will remove Scotland from the bill's provisions. And the practical impact of that is this. Agencies such as Police Scotland will continue to rely on existing legal basis for authorisation. The Court of Appeal will then give its ruling. Should that ruling find against current practices in Scotland, all such practices will have to cease immediately. Our police would not be able to conduct activity which the Cabinet Secretary himself described as vital to disrupting serious crime. And as the Cabinet Secretary acknowledges, this Parliament, in the middle of a pandemic, would be required to convene, draft, debate and try to pass emergency legislation to put that conduct on a clear and consistent statutory basis. And every day that passes without that emergency legislation in place is another day when organised crime, cybercrime, trafficking could continue unhindered by covert monitoring. Presiding Officer, this is vital legislation which provides a clear and consistent statutory basis for public authorities to keep the public safe. Failure to give consent risks leaving Scotland's people exposed. That is deeply irresponsible, and I cannot believe that any MSP would vote to countenance such a situation. Thank you.
Thank you. Rhoda Grant to be followed by John Finney.
Thank you, Presiding Officer. We support the Scottish Government in rejecting this LCM. Covert human intelligence is carried out in several ways and can mean a police officer infiltrating a criminal organisation or police officers gaining intelligence from people in or close to criminal gangs. Presiding Officer, there's a number of issues with the LCM on covert human intelligence sources, criminal conduct bill. The officers filtrating criminal gangs will be involved in criminal activities. The legislation overseeing that activity is required to be cognizant of the stresses that they are under. It is crucial that oversight is provided by an independent commissioner and that oversight happens before any criminal activity takes place. If an officer is to be placed covertly in a criminal gang, The parameters for that activity should be signed off beforehand. If these parameters need to change, then again, that must be signed off before immunity from prosecution. The bill is not strong enough on this, and it allows for a crime to be committed before it is signed off by a commissioner, and this does not provide the correct balance of authority. There are also some crimes that surely cannot ever be sanctioned by the state, including murder, rape, and torture, for example. If a covert officer finds themselves in a position where they believe they must commit a crime that has not been sanctioned and have no time to seek authority, then that must be examined through the criminal justice system. If they believe they have no choice and not carrying out the crime would endanger their life, the courts will not find against them, and because they will have acted in self-defence. If they believe they can justify it, they should have no fear of prosecution. Indeed, if it were not in the public interest, they would not be prosecuted at all. If covert intelligence comes from an informant, the police cannot be responsible for their behaviour, and the state cannot give them immunity from prosecution, because many of those people are often involved in criminal activity. The other issue with the legislation is where covert intelligence can take place. We have all heard of examples where covert intelligence has been placed within legal organisations such as trade unions or climate change activist groups, which are an important part of a functioning and open democracy. To infiltrate their lawful activities is an assault on all our freedoms. Operations cannot be used for political purposes and must be reserved for the most serious criminal activity only. We've all heard of cases where covert officers formed relationships and even had children whilst undercover, deceiving women into believing that they are someone they are not. This is rape. Someone cannot give consent if the person they are consenting with does not exist. If required, the Scottish Government must bring forward its own legislation with the right checks and balances, but we cannot support this legislative consent motion and therefore support the Scottish Government's motion tonight.
Thank you. John Finney, to be followed by Liam MacArthur.
Thank you very much indeed, Presiding Officer. I don't dispute there's a need for covert work and acknowledge that that may involve some law breaking. I'm referring to dangerous work, much like colleagues have outlined. So we welcome legislation in this area, just not this legislation, which, as others have said, aims to provide an express statutory power to authorise a covert human intelligence source to participate in criminal conduct when it is necessary and proportionate to do so. Now, I believe most people would not see it reasonable, necessary or proportionate to suggest that torture, murder and sexual violence be included in any such authority. This is about the express limits of legislation, and Amnesty International, and I declare a membership of that organisation, say, and I quote here, without express limits. And good grief, the United States has express limits in what can be authorised. Without express limits at the authorising stage, we worry that even improved oversight would leave too great a scope for abuses. Now, there was also talk of oversight by commissioners. The Investigatory Powers Commissioner said that the MI5 systematically kept vital information from him to falsely justify surveillance warrants, and suggested that the agency is failing to reliably record the kind of crimes in which their agents become involved. As others have said, this bill relies on the Human Rights Act as a safeguard, but this UK government does not believe that the Human Rights Act applies to abuses committed by its agents. A UK government that's seeking to sanction crimes committed by armed military abroad. Presiding Officer, Mr Pat Finucane was a human rights lawyer in the north of Ireland, murdered by the UK state. The UK government's own inquiry led by Sir Desmond de Silva QC confirmed that. UK Prime Minister David Cameron apologised for it. We know the members of the public still harbour grave concerns about the untimely deaths of others, such as Hilda Morrell and Willie McRae. We know UK state agents have stolen the identity of dead babies, formed intimate relationships which have been rightly referred to as state-sanctioned rape. We know about complicity and rendition, the use of Highlands and Islands airports, abduction and torture. Judicial oversight, prior or otherwise, would not be enough to secure SGP support for this legislative consent memorandum, simply because we don't trust the UK's state agents. Greens don't want the potential human rights abuses, including murder and torture, punishment shootings, kidnap or sexual offences, or conduct that would interfere with the course of justice being, and I quote here, rendered lawful for all purposes. Presiding Officer, for all these reasons and more, we oppose the granting of consent and will be supporting the Scottish Government motion. Thank you.
Thank you very much. Liam MacArthur.
Thanks, Deputy Presiding Officer. As others have said, the existence of a need for undercover agents is widely accepted. That circumstances may arise as part of such work that force the individual to act out with the law is a natural, if uncomfortable, extension of that concept. Having such an option available to our law enforcement agencies, however, is in the interests of our national security. The intelligence gleaned from infiltrating a terrorist group intent on committing atrocities, for example, could save lives. Indeed, it already has. Stepping out with the law may be necessary to do this effectively. But it is also right that the authorisation of criminal conduct by covert human intelligence sources is set within a robust statutory framework. In that regard, this bill is overdue, but it is also deficient. Unfortunately, the proposals put forward by the UK Conservative Government overstep the mark. My Liberal Democrat colleagues at Westminster, working with other parties, have sought to make changes that would deliver a more proportionate but effective set of legal safeguards. While there have been successes, too often UK Conservative ministers have refused to budge. So we have a bill which places no limits on the type of crime that could be authorised. Not rape, not torture, not even murder. No requirement for prior judicial approval of authorisations. All of which leaves open the prospect, the risk of anything being licensed in the interest of the economic well-being of the United Kingdom or to, quote, prevent disorder. That is not the way to build public trust and confidence, nor is it the best way to protect public safety. Deputy Presiding Officer, the powers we are debating today are necessary, but must be drawn proportionately and with human rights very much in mind. Unfortunately, despite the best endeavours of Liberal Democrat and other parliamentarians at Westminster, the efforts of the Cabinet Secretary and his officials, such proportionality has not yet been achieved. This is genuinely not a position any of us would have wished to find ourselves in. Legal certainty is needed, not least by those we ask to carry out these highly sensitive, difficult and often dangerous roles on our behalf. Scottish Liberal Democrats will continue to work constructively with colleagues across this chamber to make sure this happens through urgent legislation if necessary, but we cannot support the provisions set out in the bill as proposed. Thank you.
Thank you. And a brief open debate contribution from Neil Findlay.
Is it 2 minutes, Presiding Officer? Thanks for calling me Presiding Officer. I've campaigned on this issue for a decade, and because the Spy Cops scandal is one of the great policing scandals of our time, over 1,000 social justice groups like the Stephen Lawrence campaign, MPs, trade unions, environmental activists, all infiltrated by agents of the state, some using the identity of dead children and having intimate relationships with women, bearing children to them whilst they were under an assumed identity. The bill seeks to introduce a power to provide officers and agents with advanced prospective immunity from criminal acts up to and including murder, with no limit on that, and receive immunity from prosecution. This is at the heart of this. It goes to the very heart of our legal principle. No longer will every citizen be equal before the law. We know the scandals that have emerged under the current system, where there is no immunity from prosecution. Imagine the sort of abuses that will come if there is full immunity from prosecution. This is a departure from any legal norms that we have. It is a human rights scandal waiting to happen again, and Scotland has its own legal system, and if the Scottish Government want to legislate in this area and the Parliament wants to legislate, then let's bring it forward and have that debate and scrutinise it. Let's not accept the fact that Priti Patel or any other Home Secretary can authorise an order under this bill that would give MI5, MI6, police officers, the Gambling Commission, the Food Standards Agency and many other officers carte blanche immunity from prosecution for crimes committed in the name of the state. No one is arguing undercover police officers' work is not important in terror or terrorism or crime or organised crime or drugs, but this is not the way to do it. Liam Kerr seems to want actions up to murder to be given immunity and be regarded as lawful. That is an extraordinary situation. And can I say that as someone who has campaigned in this, if anyone wants to read the testimonies of victims who've come before the undercover police inquiry, then go and read them and ask yourself whether you've done the right thing in rejecting this LCM tonight, or indeed if you support it. I would also say that the issue of prior approval from immunity is not a safeguard. What we should be introducing is not total criminal and civil immunity, but a public interest defence to be considered prior to any court proceedings. I think that is the way to go, and I think that we should be rejecting this. It is an affront to our democracy, it's an affront to our legal system, and I think actually it's an affront to this Parliament. So let's reject this, bring forward legislation, and let's debate and discuss.
Thank you very much, and I call on Humza Yousaf to wind up. Cabinet Secretary.
Thank you very much, Presiding Officer. I'm conscious of time, so I'll aim most of my remarks towards Liam Kerr to address some of the issues that he raised. Let me say from the offset to Liam Kerr, I appreciate his acknowledgement of the engagement that I have had with opposition members, but also I know Police Scotland spoke to opposition members where they required additional briefing as well. And I hope, and I'm certain he does, Liam Kerr would acknowledge that the government understands that in some cases, of course, that covert sources will have to break the law. Be it in terms of the Misuse of Drugs Act, but ultimately, or indeed any other piece of legislation, ultimately to safeguard themselves, not to have their position compromised, nor to compromise important operations, whether they are drugs operations, human trafficking operations, or indeed operations in relation to child sexual exploitation. So I hope there's an understanding here that the government certainly comprehends and understands entirely that there may be cases where CHIS will have to break the law. What I would say to Liam Kerr, though, in his remarks, or in response to his remarks, is that in essence what he's asking the government to do and this Parliament to do is to agree to a bill which does allow and sanctions covert sources to break the law without any prior independent judicial oversight, with huge human rights concerns that have been raised by very reputable and respected human rights organisations, that does not on the face of the bill make it clear that there is some non-permitted conduct such as murder, torture or sexual violence. And he asks us to do that and essentially for the reason that it may be the easier of the two options in front of us. And while it may be the easier of the options in front of us, I'm afraid it's not for me the morally correct or indeed the most principled route for us to take. He talks about, in his remarks, the hard cliffage, and I recognise that there could be a remote possibility of that cliffage. But firstly, let me say I think it's unlikely that there will be an immediate hard cliffage. For all the operational challenges that Liam Kerr mentions, I think it's very unlikely that a Court of Appeal judgment would come to a determination that creates such operational difficulties for law enforcement agencies and security services. But I accept his point. It could happen. And if it did happen, then yes, ultimately, in that unlikely scenario, then we may have to reconvene, come together and meet to approve emergency legislation. That is possibly what we may have to do. But let me give an absolute assurance that if we did do that, in terms of emergency legislation, which would be, to hopefully address some of Neil Findlay's points, would be simply a sticking plaster, a stopgap, in order to preserve police operations, that I give an absolute assurance that as part of any Scottish emergency legislation, I would guarantee prior judicial oversight. And what I would also guarantee, and I can only make this guarantee on behalf of this government, that post-election, if a bill was required, and if that was what we came to determination that was needed after we digested the Court of Appeal judgment, then this government, if re-elected, would bring forward a bill, would discuss with opposition colleagues what that bill should look like, would do that in the fullness of parliamentary scrutiny, and we would open up discussions, although Neil Findlay, of course, is standing down, but with other opposition members, we would, of course, speak to them about what approach that bill should take, whether it's in relation to a public interest test or indeed whether it's any other red lines or indeed important principles that they think any bill should have. So in conclusion, Presiding Officer, the House of Lords third reading will take place, as I said, on the 21st of January. The UK Government have confirmed they will table amendments removing the provisions relating to RIPSA and the amendments to the Regulation of Investigative Powers Act, RIPA, for devolved purposes for the bill. We will await the Court of Appeal judgment and the extent to which, if any, it may impact law enforcement operations in Scotland, and I will carefully consider what further action is required, and I move the motion in my name.
Thank you very much. That concludes the debate on the Covert Human Intelligence Sources Criminal Conduct Bill legislative consent motion, and we'll move on in a moment to the next item of business. May I remind members to observe social distancing requirements, including when leaving and accessing your seat in the chamber.